what are we looking at? I mean, going through the petition this time round, what differences or similarities can you draw from both cases?
I think one has been brought by Kenyans, taxpayers, John Jomwe and Halif, who are leaders of non-governmental organizations. And they are coming in to draw the attention of the country that certain things were not done right, and that democracy allows them to petition, where the other parties have actually not shown any kind of interest. And it's like the Constitution is under test by the owners of the Constitution. They are looking at the position that was not, they are looking at what ought to have been followed that was not followed. What the IEBC ought to have done as per the law and the Constitution, and what the loopholes that were there that have not been sealed. So if you compare the similarities, it is just that it is similar, but the players are different, in that Kenyans have come in and they have looked at it and said, you know what, we cannot just let NASA boycott the whole thing and not go into court. Let us go to court and see. This time we had Section 290, is it? Section 290? Oh, no. Yeah, if we look at paragraph 290 of the 2013 Supreme Court decision, yes. And then we also come to look at Article 138(2) of the Constitution, which says that the presidential elections must be held in all the constituencies. In the previous litigation, yes, they were held in all constituencies. This time, there were 25 or 27. Is it 25, yes, 27 that were not held? So they want actually to test the Constitution and to find out what the courts will have to look into.
All right. So that does that go back to the the process? Because back in the August 8th petition, the process is what the petitioner at that time, NASA, used to punch holes in the whole electoral process. So are we looking at the same situation, that it's questions about the process of the election?
Yes, I'd like to look into it. I can see maybe 3 or 4-fold differences from the first presidential petition, number one. The first one, of course, he's mentioned on the threshold, which is elections being held in all the 290 constituencies. We know of it's a fact that there are some constituencies that voters didn't get to exercise their right. Then, secondly, we'll get to maybe have a good end to some questions that have been through the High Court. Now they're back to the Supreme Court. First of all is on the issue of fresh nominations being held. Yeah. So should fresh nominations being held after annulment of a constitution? You know very well this is uncharted waters, because this was the first time a presidential election was dismissed by the courts. Yes. So this is an issue that maybe we'll have final determination on. Then, secondly, there is also an issue to do with the conduct of the elections in the constituencies. Anyway, what I also wanted to talk about in terms of differences, last time they challenged the process in terms of the forms 34A, B, C, the authenticity, were they verifiable? But this time, John Jomwe and Halifa have brought in a new aspect. This is the manual voters in the register. Those not manual voters really, but voters who are identified manually. Through the alphanumeric. So I'd like to maybe simplify this petition to be one that is against Uhuru Kenyatta versus the voter turnout, because in her submissions yesterday in her application for scrutiny, Advocate Juliet Soweto really was, saying there are some instances where turnout exceeded the number of registered voters, and they want to know the exact turnout. So this time round we'll be introduced to the Form 32A, which is the form that the officials get to sign when a voter is identified via the alphanumeric search. You'll remember very well the turnout kept on changing from 48% to 33% to 88%. So this time round really is not too much into the process. Maybe it's about the numbers in terms of the turnout. So that's why they want an order to scrutinize the data that is in the KIEMS kit, the SD cards so that they know what was recorded at the close of the polling station to have been the turnout. So was it, exemplified? What did they, magnify the actual turnout of the voters?
Interesting.
Yes.
All right, Professor, also coming to the issue of the fresh nominations, there's a time that IEBC, as we were waiting for the October 26th election, Wafula Chebukati moved to the court to seek guidance from the court and direction as to, him as the national returning officer for the presidential election, if he can be able to alter, to verify, to change anything about the results that come from the polling centers or stations. And, the critics were saying that maybe he should have taken the opportunity to also ask for more information when it comes to whether, IEBC should be able to conduct a fresh nomination, as was, in the case by Harun Mwao, the former Kilome Member of Parliament. Do you think that maybe IEBC brought itself where it is right now on the receiving end yet again?
Actually, the lawyers who advised IEBC at that particular time made a fundamental mistake, and that's why the Supreme Court made a very quick decision referring them to their previous decision. I think they did not read what the Supreme Court had done. And on top of that also, the Supreme Court, though advisory, it has jurisdiction on certain matters, not any trivial issues taken in. What was Chebukati trying to validate at that particular time? Why was he going into a gray area, muddy area that he was not even supposed to look, an area which ought to have been brought in by litigants of the approved group through litigation? By taking that mantle to himself by saying that he wanted to get advice on whether he can verify papers. That was like legitimizing a thief to go and steal so that you don't take him somewhere. So he failed miserably. And from that particular time, you have seen a cross-grouped kind of litigation coming in following that kind of an intended decision by the IEBC. He was not thinking before acting, and you can see the retribution. And also, there are certain things that he did that were not right. He put names of other presidential candidates on ballot without those names being gazetted. One of the names was Jirongo's name. And also what he didn't realize is that he should have sought clarity from the ACC, anti-corruption, on the issues of Jirongo, because prior to that, Jirongo had just been declared bankrupt, even though he went to court for a stay. But that in itself was questioning the authority of the legitimacy of the anti-corruption, what have you. So most of the issues here actually were instigated by Mr. Chebukati himself.
Yeah, maybe just to add, another thing that maybe might have thrown a spanner into the works is the recent amendments that have, I think, that have since become law. The Elections Act was amended to read fresh nominations. When there is fresh elections, then nominations should not be held. So I don't know if the Supreme Court will consider it in making its learned decision. But apart from that, as rightly pointed out, there's also another gray area that really is also sought to be interpreted. The effect of abduction by a candidate, abandonment. Actually that's a new word.
Abandonment
in the race. So Njonjo Mu and Halifa in their petition say that the independent commission ought to have conducted now fresh elections within 90 days in the pretext of Article is it 163(6)? Yes, when abdication of a presidential candidate in the race. So this is also another area we'll want to know now. What is the effect? If I petition, I challenge his victory, then I choose also now to opt out of the race. So what is the implication to that? Okay. So that's also something that the court will want to hear how it will pronounce itself.
All right.
And also another issue that was not addressed is what if a candidate or one of the participants accepts and acknowledges the winning of the other party.
Yes.
And later on, matters come up, and I'm talking of Dr. Okuru Okot and Dida. They came in, they accepted and acknowledged Uhuru Kenyatta's victory, and they issued a press statement on that. And later on, they turned to become candidates. And Chebukati included them on the list. I mean, do we have some lacuna here that can be looked into? And on top of that also, does Dr. Ikuru have any integrity of swallowing what he has already vomited and turning around to take advantage. So those are the things that we also need to address in future.
All right, finally, gentlemen, I was speaking to a number of legal minds, just the other day, and they said that, this process, as much as it's time-consuming, maybe it's, developing into fatigue for Kenyans and even the court and the whole system, that it's a good thing that, we are building our jurisprudence when it comes to the, elections, and maybe we might be an example. Actually, we already are an example to so many other countries. Is that, the same feeling that you have?
Absolutely, yes. As Professor rightly put out, if there's a time the Kenyan Constitution 2010 is being put to test, is during this time. We also remember the unfortunate occurrence in Nyeri when the governor passed on, and people are shocked now, to discover that there'll be no by-election and the deputy will take over for the remaining time, and maybe there are some sentiments from the residents of Nyeri that maybe they might have wanted to reconsider. So this, some of these occurrences, I think, is for the good of the republic. It may be coming with some economic consequences, of course, but of course, this is, we want, if the legitimacy of an election to be upheld, then the only body that can do that is the Supreme Court. So if, every right as a voter, yesterday I saw one of the, there was somebody who went as a voter, James Maina, and he said, as a voter, I think my right was infringed in a certain way. I maybe did not have opportunity to look at his application. So it is every voter's right to...
He actually said his arguments would finish that case in 15 minutes. Maybe very ambitious.
Well, so maybe there might be 19 million others who maybe think the same. But for me, in terms of jurisprudence, for those of us who are part of the bar and the legal minds, it's good for the Republic in terms of developing our jurisprudence and everything. And let us wait and see what will happen in the coming days.
All right, interesting. Your final thoughts?
Yeah, constituting constitutionalism is something that cannot just be done immediately. If you look at where we are today in terms of the constitutions and the laws that actually come in to validate the constitution, and you apply the American theories in what we call the Lewisian theory, law is not law until it's tested, and it takes a longer period to test the law, whereby parties have to go to court to look at the validity of that law. And it's up to the Supreme Court to make a decision, and once they make a decision, then that decision invalidates that law or validates that law. And that is a process that takes a very long time. If you look at the US again, and look at the common law, the growth of common law in the absence of written constitution and the Bill of Rights in the UK, you'll find out that if you look at the time frame, from the time when the constitution was constituted to constitute itself, it's a walking distance that's miles and miles and miles. And the Kenyans are on the right path, because they are looking at every segment. What is this? Can we go to court? And can the court validate? Can the court look into it? And it's only after the final tallying by the court that it becomes now a threshold to be applied and to be followed for the rest of what have you. And if you look at the late Ogembo's writings, it's one man that I respect very much, and sorry to divert into this. He wrote one book that took me ages to understand, Constituting Constitutionalism. It took me to be taught how to read it, just like reading Shakespeare. So it's like a birth of a child. A child cannot just be born without going through certain periphery. So Kenyans are on the right path, and let us see how it goes.
All right. Thank you very much, gentlemen, for your time. I've been speaking to Professor George Ojakoya. Yeah, he is an advocate in the High Court, and also he's a lecturer at the at USIU, the United States International University. Is such a mouthful, but thank you very much for your time. We have also had Collins Mango, who's also a lawyer. Thank you for your time. All right, so as we await for the beginning of the Supreme Court session this morning, we'll be taking a look at other top stories that we are also following up on. One is what's happening in Zimbabwe. And like I mentioned earlier when we started, we understand that, the still uncertainty has continued to reign in Zimbabwe after the military took position in the capital, Harare, since yesterday. I'm sure you've been seeing what has been happening on social media. Now, we understand a military officer, and we had him in the morning, read out a statement after taking over the national broadcaster ZBC, saying it had taken action to target, and I quote, criminals. The statement said that there was no military takeover of the government and that President Robert Mugabe was actually safe. It is not yet clear who is leading this military action, but the military chief general, Constantino Chwenga, had challenged 90-year-old Mugabe's decision to sack the Vice President Emerson Mnangagwa. So that's one of the top stories that we're focusing on. Still, the information from Harare quite scanty, but we'll continue to get more information for you here on News Center. All right, so let's take a short commercial break. We're coming in to continue with our coverage in a few minutes. Don't go away.